Well, if you have been hurt through no fault of your own, you might be thinking the only way to resolve it is in a courtroom.
But most cases are actually settled by a mediator and never reach trial. Here to explain the process, John Claypool, partner and personal injury attorney at Herrling Clark. Good morning.
Good morning.
So what does it mean to have a personal injury case go through mediation?
So contrary to what most people think, very few cases actually ever wind up at trial. I would say probably about 90% of the cases never or settle. 10% tops find their way into the courtroom. In the last 15 or 20 years, mediation has become very popular. It's oftentimes ordered by the court, which requires the parties to meet with a mediator like myself in an effort to try to get the case settled.
Why would you say this is the preferred way to settle specifically a personal injury case?
Probably the main reason is expense. Putting a case together for trial, expert witnesses, the time commitment. I would say expense and time is the main motivating factor behind trying to get it settled at mediation. Now, having said that, I've been a trial lawyer for 35 years. I still very much believe in the trial process. It works. So some cases, you know, the old saying, reasonable minds can differ. That's okay. Sometimes cases just need to be tried and a jury needs to make the decision. There's nothing wrong with that, but in the majority of the cases, I think mediation definitely makes sense.
Well, I had asked you earlier, who are the mediators? You have to be a lawyer to be a mediator, correct?
I mean, you can be a mediator without a law degree, but I don't think you would probably be very effective, to be honest with you. Most of us, there's only a handful of us, most of us are trial lawyers who have been doing it for a long time. Sometimes you see retired judges as mediators, but I would say most of us that do it were trial lawyers for the greater part of their career, which I still am. I still consider myself a trial lawyer first, a mediator second, but clearly most of us have a lot of trial experience.
Sure. Talk about how the process actually works. Okay,
so what typically happens is most of them happen after a lawsuit's filed. Sometimes there's pre-suit mediation. That's pretty uncommon and generally not very effective. After a suit is filed, there will be a scheduling order where the court sets various dates. One of those dates is the date by which the parties must hire a mediator and at least attempt to have the case settled. So once we get a date set for mediation, generally about a week or two before the mediation session, both sides will send me written materials outlining their case. I'll review those materials, so I have a very good idea what the case is about prior to the session. And then we have a meeting. Surprisingly, the parties rarely meet at mediation. They probably rarely even see each other at the mediation. Back when we first started doing these, we would have this group session where we would all meet, give kind of an opening statement, but nobody does that anymore. So then once we have the meeting, I explain the process to the parties, and then the negotiations begin.
Well, wherever you are, you know, whether you're going mediation or trial lawyers, they are the expert in both. You'll find Herrling Clark offices in Appleton, Green Bay, Oshkosh, and Wapaka.
Give them a call, 920-739-7366, online, herlingclark.com.
Thanks for joining us.
Okay.